Good morning, all. Welcome to our 5 Tips for Experts webinar. Our guest today is Guy DiMartino. Guy is a civil trial lawyer, a chiropractic physician, a pastor, and an expert witness. He is a Florida board-certified trial lawyer, also licensed and practicing in Indiana. His background in law and chiropractic medicine have given him a unique perspective and extensive experience to effectively represent clients. It has also given him the skills and knowledge as a chiropractic expert witness. So I'm really excited to have Guy here today. Guy, thank you for being here. You've got just a ton of experience that you can share with our expert witnesses, our members, and both from a trial lawyer perspective and from a practicing expert witness. Thank you for being here. Anything that I missed that you'd like to add in before? No? All right.
Thanks for having me, Nick.
Thank you for being willing. So I'm really excited for this, and we'll jump right in. You've got 5 tips for experts. Tell me what you need from me as we go.
Okay, I will. So let me go back. Since the 1980s, when I was a chiropractic physician, being in healthcare, it comes very close, especially if you're treating patients, to legal issues, whether it's health insurance or whether it's treating people who are involved in accidents or bringing up some type of claim. So I've had the ability to testify on behalf of folks who were my patients over the years in arbitration, in civil matters, in criminal matters, when it comes to abuse and things along those lines. And then I've also had the occasion to testify on behalf of defendants in chiropractic malpractice cases, on behalf of plaintiffs, patients who are bringing the claims. And then I've had the ability to defend cases involving expert witnesses and prosecute cases. So I hope today I can bring some nuts and bolts to this discussion. Now, what I'm going to tell you, there's not only one right way. It's just going to be a Guy's way.
Okay. And that's what we're looking for. Appreciate that.
Let's get started.
Sure. I'm ready for this next slide here.
Yep. So what we're looking at here is we're looking at, the expert witness. What makes somebody an expert witness? You can go to the next bullet point. What makes you an expert is knowledge, education, and experience. Now, you don't need all of those. You can have knowledge and experience and not necessarily the education. Because if you're in a body shop and all you've been doing is fixing cars, or if you're like Marissa Tomei and my cousin Vinny, her dad was a mechanic, her brother's a mechanic, her sister's a mechanic, the mechanics. And so the purpose of being an expert witness is that you're able to assist the trier of fact with something that is not within the common person's experience. So it requires a certain amount of expertise. In legal terms, this is what we have. The next click.
Yeah, I'm sorry. There we go.
Okay. It's a witness who's qualified as an expert by knowledge, experience, and training or education and may testify in the form of an opinion. And so that's the difference. If you are a layperson, you can testify based on your own personal factual knowledge and things that extend from that. But when you're an expert witness, you do not need firsthand personal knowledge. You can rely on information that all other folks give you in your type of work, plus your education, training, and experience. And based on those things, information that has been given to you, and it's something that's reasonably relied on by you and your profession, and your education, knowledge, and experience, you have the ability to pontificate. You have the ability to give your opinions. And that's what makes an expert witness different than a regular fact witness.
Mm-hmm.
Next point.
Next point.
So, expert scientific testimony is only admissible if the court is satisfied that the expert testimony rests on reliable scientific principles. And so there's two trends of thought. There's 2 laws regarding expert testimony. You have Daubert and you have Fry.
Mhm.
FRI is the generally accepted principles, which some states still have. And then you have the Daubert information, which requires it to be based on reliable scientific principles. So if you're in a FRI state, or if you're in a state that has a quasi-Daubert, you might be able to testify based solely on your opinion. I've been doing this for 25 years. I can testify on it. It's my opinion because I've treated or I've done this so many times. And if you're in federal court, or if you're in states who have followed Daubert, there's a lot more hoops that you need to jump through. And that's something as an expert witness that you have to understand when you're going into the case.
So they should probably be aware of what their jurisdiction or the jurisdiction in which they've been asked to testify, which rules, which are they following, FRI or Daubert? That's something they're going to want to know.
And that's something you're going to want to get up front from the lawyer. For instance, if I'm in federal court, when I have my pre-engagement appointment or conversation with the expert, I'm going to ask them, do you have a testimonial history? Have you kept track of your testimony for 4 years? Because if you haven't and you can't put one together, I can't use you because that's a requirement in federal court. Okay. But if we're in Florida state court and you don't have one, you don't have to produce one.
Gotcha.
So it all depends upon where you're at in the United States.
Okay.
Next slide.
Excellent. So you've got a tip for us.
We do. First tip. Going into an expert relationship is very much like we are going to have coffee. This is what I call the pre-engagement conference. And we need to have a pre-engagement conference. We need to talk. We need to spend a few minutes. We need to make sure that I resonate with you and you resonate with me. I need to determine if the case is something that I think you can help me with. And you need to determine whether you want to handle or help me with my case. As a general rule, when I'm an expert witness, I don't charge for this pre-engagement conversation. But you can charge a nominal fee. You just need to let the lawyer know up front. Okay. You see, because after our conversation, we might not resonate. Let me give you a for instance. There was a highly qualified doctor that I recently contacted on the East Coast. We initially contacted through email. We had this email correspondence. We set up our coffee date. Mm-hmm. Before the coffee date, I send the gentleman an email and I say, I need to know a couple things. Number one, are you in active practice? And number two, have you ever filed the expert witness certificate that's required in Florida? He snapped back at me and he said something to the effect like, I'm at my office now. I'm in active practice. I wasn't asking that because I was checking his qualifications. I was asking that because before I even wasted his time, if he wasn't in active practice and based on Florida law, if you're not in active practice or you don't teach at a school and spend your time teaching, you can't act as an expert witness in a medical malpractice case.
And it sounds like there's one more step in Florida that they have a certificate that they have to file as well.
Right, but that's it costs $35. I have no problem paying it, but you have to go on the DOH website and you have to fill out an expert witness certificate, just saying that you are who you are. Gotcha. And that should you lie, cheat, or steal, you're bound by the Florida Board of Medicine or Florida Board of Osteopathy or whatever healthcare board, rules you. So this pre-engagement discussion is very important. You see, you might not like my case. I might not like you. Mm-hmm. You might not like me. So, no harm, no foul. You just might not be the right expert for this particular case. Okay. So we've had our pre-engagement coffee. We sat down and we decided we want to take a step further. And the next thing we're going to do is tip number 2. And that is we're going to get engaged.
I love this picture that she chose for this guy.
Yeah. Aren't we? We are going to get engaged. So when you get engaged, there are a number of things you need to discuss, right?
Yep. You ready for them?
Discuss. What do we need to discuss? Number 1 is scope. There are so many ways that an expert witness can help in a case.
Mm-hmm.
You can be a consulting expert. You can be a teaching expert. You can be an expert that just goes out and gathers the information. For instance, if it's a bad auto accident, I might just need somebody to go out and take photos, pull the black box or the EDR and download it, preserve evidence, measure skid marks, and it might not be something that ever is used in the future because the other side might stipulate the liability and say, you know, we're at fault for the accident. Okay. The other thing is with scope, I might need you just to help me or teach me how to use that widget that you have all the experience in, whether it's a seatbelt failure case or whether it's based on some widget or whether it's an accounting principle. In the past, I've used my wife, who's an enrolled agent and she has a master's in accounting. I've used her to help me and educate me with balance sheets and finance sheets in cases. So I might need you just to educate me regarding the stuff that I need to know.
Okay.
I might need you, if it's a medical case, no matter where you are in the country, if it's a medical case, there's usually some type of pre-suit requirement, whether it's an affidavit of merit, whether it's an affidavit of corroboration, whether it's filing a proposed complaint with some administrative agency. I might need you just to look at my case and tell me one thing. Is the standard of care met? Is there a deviation from the standard of care? So we need to discuss scope because not every case is the Taj Mahal. Not every case is a multi-million-dollar case. I might need you as an expert witness to just help me get past summary judgment in a slip and fall case.
Mm-hmm.
To talk about some ANSI code or talk about, some code. So I think the scope is something that we need to discuss, and we need to discuss it up front. And
should that also be part of that? Should that then be put into writing in an engagement, a retainer letter or an engagement letter?
Yes. And that way everybody knows.
Okay.
Right. The next thing is communication. How are we going to communicate? I've been left in the lurch by some expert witnesses in the past because, I'm up against time deadlines and I cannot get in touch with them. If it's your preference to communicate by email, that's fine, but you have to understand as an expert witness, I don't want you putting anything substantive in an email. Why? Because at some point in time, if you are deposed, those emails are discoverable. And I don't want to make the other person's job for them. I don't want to give the other side a roadmap, whether I'm on the plaintiff side or the defense side, for them to be able to depose you. If you spill out all your guts in an email, you are giving them a roadmap to question you and things along those lines. So my communications with you are going to be, hey, let's talk.
Gotcha.
Let's schedule something. Here is A, B, C, and D. Here's your retainer check. Whatever it is, that's going to be the extent of written communication if you're working with Guy DiMartino.
So the emails, any written communication really should be to set up a phone call. Sounds like it. That's your preference.
Yes.
Yeah.
But we can exchange information by email. I can give you a link to electronic documents or videos or whatever it is, but nothing substantive. All you're doing is doing the other side's job for them.
Okay. Excellent.
The next thing I want to know is, what do you expect from me? I have laid out my problem to you. I have laid out what I want. I need to know what you need in order for you to do your job.
Okay.
You have to give me a wish list. You have to tell me, I want to see A, B, C, and D. I need you to go out and get this. Okay?
Yeah.
The next point is, what do I expect from you? The number one thing that I expect from an expert witness is I expect them up front to do a quick analysis of my case and tell me if they can help me or they cannot help me. And I want them to do it cheaply.
Mm-hmm.
I want to know, because I'm a small firm, I'm by myself. Every dollar that I spend is my money until at some point in time I get a contingency fee back and I'm reimbursed my expenses. Don't think that just because we like each other that you have to go beyond your values, your mores, who you are, in order to do something because I am the lawyer that retains you. I'd rather know up front that this case is just something I don't feel comfortable with, or I want to know every weakness and every rat hole that the other side is going to go down so we can try to plug that up.
And that,
it's about open communication back and forth.
And that frank communication could save you, right? An expert being upfront with you early on about, hey, guy, this is not a great case, and this is why I think this. That could save you a lot of time and effort down the, well, maybe this is something I need to settle because maybe it's not spectacular.
Exactly.
Okay.
Okay, next point.
Next point. Oh, tip 3.
Tip number 3. Here we have report or no report.
Mm-hmm.
Because there it goes back to the scope and where you're at. You need to rely on the attorney to explain things to you about the jurisdiction that you're in. If we're in federal court, you can go to the next slide. We know that we need a written report. We know that we're going to have to follow the disclosure requirements of Rule 26.
Mm-hmm.
But if we're in Florida State Court, I don't need a written report unless it's in the order from the judge. And you have to rely on me to tell you about the jurisdiction, about the court, about the mannerisms, and about opposing counsel. Because even though you think there's a lot of lawyers, there's a very small amount of lawyers in every given practice area. We come up against the same folks time and time again. So it all goes back to scope with the written report. Next point.
Sure.
Next point.
Oh, the next. Here?
Yep.
Okay. Sorry about that.
Yep. Next point has to do with depositions. And again, it goes back to scope. And here we have all these Post-its. And these are the roles that you're going to play as an expert witness, or you could potentially play. You can help me with tactics. You can guide me. You can tell me the potential or the pitfalls for my case. You can show me and teach me where the opportunities lie. You can help me. You can be my mentor. You can revise and review my discovery responses. You can help me prepare for depositions and teach me what I need to know in order to get the facts from the fact witnesses that you need to help my position.
So this is
stir up my position.
And you've had sort of this theme that keeps going back to sort of scope and communication is what I'm getting from this guy. And all that, if we're both on the same page as far as scope and we're both communicating correctly, then you may guide me through this far simpler than I could have done on my own, because now you're guiding me which questions to ask in discovery or in interrogatories, and you're really helping coach me through this entire process, especially in an area that you may not be familiar with.
Exactly. And most of the time, most of the time lawyers have a tendency to focus or specialize their practice. Mm-hmm. I handle certain types of cases. I know the facts that I usually need in order to prove my case. And what I need from the expert is, are you able to support this? Am I barking up the wrong tree? Or what specifically do you need in order to help bolster or support my opinion? See, I don't want you to be an advocate. You need to be a teacher. You need to be a professor. You need to, have your expertise. But if I'm retaining you, you need to be on my side. You need to believe in my cause. Otherwise, we can talk about the next case that's going to come along, because there will be a next case.
Right.
Okay.
And I think I want to stop you here, because we did on Scope, we did discuss something when we were doing some preparation for this that you said, well, in fact, I should have asked it when we talked about the frank and open discussion. And I think you indicated to me that knowing that, getting that frank, hey, I cannot help you on this guy because of A, B, and C, just because that doesn't get an expert the case this time around, doesn't necessarily mean I'm not calling that expert again. In fact, it might mean the opposite. That person, he or she, gave me fantastic information and was frank with me and saved me a lot of time and heartache over a case that wasn't very good. That's the person whose advice I'm probably going to seek in the future.
Absolutely. For the healthcare providers out there, I'm sure you've had patients who you've just not been able to help. And you told the patient, you know, Mrs. Jones, I did everything that I possibly can for you, or I'm going to refer you to another specialty. How many times have those patients become your best advocate and referred you more patients than the person who you performed a miracle on? And, you know, lawyers talk. My first place to go to get a referral to an expert witness is people that I know, like, and trust.
Mm-hmm.
And, you know, if you are open and honest with me, you're going to be the first person that I am going to think about when somebody asks me, hey, Guy, do you know somebody who, you know, is a general surgeon who deals with, you know, common bile duct injuries? Or somebody who's a police practices expert, or somebody who's a canine expert, or who do you like who's a middle-of-the-road economist? I don't want somebody that's going to be over the top. I want somebody that's going to be middle of the road. So, you know, I can't, just because you might be passing on a case now or only getting a small fee for your initial review of the case, doesn't mean that the relationship will not be long-term, because I like to use expert witnesses time and time again, because I know where they're at and I know what to expect from them.
And I have to give myself a little plug, or Experts.com a little plug there, Guy, because Guy did reach out to me. We did get to know, like, and trust each other, and he reached out to me for a correctional healthcare expert witness, which you seem to hit it off well in your communication with that person, and ended up retaining him, as I recall, unless something's changed.
Nope, absolutely. You're absolutely right. I mean, so I had a difficulty finding an expert because the potential defendants are so big and the pool of experts is so small that most of the experts in the country have worked for the potential defendant. So I reached out to Nick, and Nick said, you know, you got to try this person. And then we had our pre-engagement, we engaged, and now we're going through the process.
Excellent. That's and you kept me in the loop as far as your experience with that, which I greatly appreciated, because I don't always have that communication. So I do. I really appreciate that. Would you like me to move to the next slide on 4 here?
I would.
Okay. Deposition preparation, which we covered with our mutual friend Mo just last month. So right. This was kind of your a little feedback for everybody, a little background for everybody. During the last deposition preparation webinar, which Guy was actually attending and our friend Mo was the host, Guy reached out to me and said, you know, he wanted to cover some of these items as well, because he's had the experience both as an attorney and as the expert witness, and thought that he could, and that's how today came to pass. So please jump right in.
Let's go back. Put some more of the bullet points in so we can talk about this as a. Okay, so when we look at deposition preparation, we're talking about preparation on 2 avenues. Again, it goes back to the scope of why I'm retaining you. You might be there solely to help me prepare for the deposition of opposing fact witnesses and expert witnesses. I always ask my experts the facts that they need me to get from deposition, the important questions to ask, what areas can I get concessions from the other side? What areas do I just need to punt on and just move away from and not feed up softballs to the other side? So I rely on my experts to teach me and to support me in what I'm doing. Okay. The next point, we can move on.
Okay.
Is your deposition as an expert witness. Let's see where we've gone before we get to the deposition, where we've come from. We had our pre-engagement appointment.
Mm-hmm.
We engaged. I provided to you all the information. You've done your initial review.
Mm-hmm.
You've told me as the expert, I support your case. I believe we can show whatever it is that we need to show. I've paid you for your time,
Okay.
right?
Right.
You've reviewed the file. Now it's time for your deposition. You've prepared a report. Maybe you didn't prepare a report.
Okay.
Okay. You need to be prepared. You need to be prepared for our preparation session.
Mm-hmm.
Why? I don't want to spend an hour and a half going over the facts of the case with you. We've already went over the facts, the pertinent facts in our pre-engagement appointment.
Mm-hmm.
We've gone over the pertinent facts throughout the case. You've either prepared a report, you've charged me for review of the file. I'm not going to pay you an hour and a half to review the file again and teach you the file.
And teach you the file. That it was a big aspect, I think, that I understood there.
Right. Yeah, because you have to reacclimate yourself to the file.
Mm-hmm.
What we're going to do in preparation is you have to realize by the time we've gotten to your deposition, I've sat through depositions in the case.
Mm-hmm.
I know the other side's angles. I know the questions that they've asked witnesses. I know the important facts. I know what I need to show to either prove my point or defend my point. And so my job in preparing you for your testimony is to give you the lay of the land. I've probably been before the judge in one or two hearings. I've met with the other lawyers. I've seen their style. I've seen the way they've questioned people. That's what the preparation is for. So when you walk into the deposition, even though you've been in 100 depositions or 200 depositions, I've prepared you for what you need to expect. Some lawyers are passive, other lawyers are aggressive. Do you want to know that before you go into the deposition, Nick?
I imagine I would want to know exactly that, and I'd want to know how the lawyer that retain me, I'd want to know whether or not they're passive or aggressive. I'd also want to know what the opposing counsel is like. I'd be asking the lawyer who retained me, is this lawyer passive or aggressive?
Right. Do you also want to know what the court is like that this deposition might be played in, or where you need to go?
I would definitely want to know, are we doing this by video? Or is there no video? Where will we be meeting? How should I be prepared? Should I be should I be in a suit because it's on recording? Should I be prepared for that? Or can I come a little bit more relaxed because we're not going to be recorded?
Brings up a perfect point. Let's go to the next slide.
All right. Tip 5. And should I go to the next one or leave it here for a second? Right here.
Right now, tip 5. This is the take-home information. This is what I this is Guy's beliefs.
Okay.
Tip 5 has to do with deposition and trial.
Okay.
Believe it or not, the only thing that matters in any case, is the story and the credibility of the parties.
Okay.
Only thing that matters. Experts have a tendency to dwell on the facts. And they think that the facts carry the day. And that's not necessarily true. You need certain facts in order to get past certain procedural hurdles. But what carries the day is the credibility of the expert witness and the credibility of the parties. You can have gaps or holes in the facts and still win the day, whether you're on the plaintiff side or the defense side, if the folks are credible.
So this
all
is
about credibility.
So this is like, if we're thinking of it in some sort of theater sense, we've got actors on the defense, actors on plaintiff side, and we're looking at which group is more credible.
Which story makes more sense? Exactly.
Okay. All right.
Right. Next point.
All right.
So you have to look the part. And this is where you need to know, is it a videotaped deposition? Or is it not a videotaped deposition? You see, if it's not a videotaped deposition, I don't care if you come in shorts and flip-flops. But if it's a videotaped deposition, I want you to look the part. Because what happens if you're not available when we go to trial? What happens if something happens to you? What happens if the court changes the dates? You see, deposition testimony can be used as trial testimony for expert witnesses in most jurisdictions, and deposition testimony can always be used if the witness is unavailable. And unavailability depends upon where you're at. In federal court, they say it could be 100 miles from the courthouse. So you have to think about that.
And you had given me a little bit of input on this before we go into this credibility contest a little more. You said you didn't want somebody coming in with the big gulp of Mountain Dew and putting that on the table in front of where the camera. You had some experience or something that really comes off looking poorly when the recording is maybe reviewed later at trial.
Absolutely. I had this orthopedic surgeon come in. He had his scrubs on. His hair was disheveled. He had a quart-sized Mountain Dew. He places it right in front where it obstructs the scene. My client sees this deposition in preparation for trial, and my client says, he looks like a surfer boy. He has no credibility. He couldn't even sit up straight. You have to look the part. She says, you paid this guy $5,000 to testify,
And that hurts you. That will probably make you not want to use this person again in the future, right? Use that expert. Yeah.
Correct.
Now, we had a question that's been sort of a repeat question from one of our members who is a construction expert, and this seems to be the appropriate time to cover it. He had asked how he should look in deposition and at trial. He's a construction guy. He's in jeans and in the t-shirt every day while he's out there working on construction projects. Should he dress in the three-piece suit when he comes to court or to deposition?
If he was my witness, I would not have him dress in a three-piece suit.
Okay.
But I wouldn't have him dress with dirty jeans and a t-shirt either.
Okay.
This is the person that I would say, I want you to be comfortable. Okay. You need to be who you are. And that might be a collared shirt, or that might be, a shirt and a tie without a jacket, or that might be a new pair of jeans. Maybe he's a jeans and cowboy boot type of guy, but he looks the part.
Okay.
Conversely, I typically do not like law enforcement folks who come in their law enforcement garb. Some people do, but everybody is, different. Mm-hmm. If you're a professional, a doctor, a lawyer, an accountant, things along those lines, I think you really need to put on the monkey suit.
Okay. And this is something they should discuss with the attorney who's engaged them.
Yes. Yeah. Because it's funny because people don't really think about that, but I can tell you my first trial. I had this wonderful African-American lady, and she was injured pretty badly in an auto accident. And she says, well, how should I dress? I said, why don't you dress like you go to church on Sunday? And she dressed in a beautiful yellow suit, but this big yellow hat. And I said, you look beautiful, but we probably want to put the hat in the car just because, just because you don't know. Like I said, it's a credibility contest, and you don't want to trigger people's biases by the way that you dressed.
Okay.
So as to this credibility contest, the expert in most cases should take on the role of the teacher.
Okay.
The expert is the one who comes into the courtroom or into the deposition and has an expertise that they have to impart to the jury or the judge. If you're a medical expert and you are there to testify regarding, say, standard of care, it's your job to step back and to teach the jury this area of medicine and why the doctor or nurse did something that was not acceptable under today's norms in this practice of medicine. Okay. What I don't want, and what most lawyers don't want from an expert witness, is an advocate. The lawyer does the advocate job. You see, so how do you become an advocate as opposed to a teacher? You fight everything along the road. There are some expert witnesses that they're asked a question from the other side, the sky is blue, and the expert will quibble with them over whether the sky is midnight blue or light blue, or possibly it's gray because of the haze today.
Ouch. And this is one I think I mentioned to you when we were prepping for this. In fact, just saw out of Las Vegas, I believe, an orthopedic expert who had become so much of an advocate for the defense as an IME expert witness. He did IMEs and was an expert witness, that 2 trial judges have said he can no longer testify in the court. He had become such an advocate for the insurance companies that he was no longer credible.
So how do you increase your credibility? First way is it's okay to make concessions. There are going to be concessions that you're going to have to make. If you were to read one of my depositions, on cross-examination, half of my answers are yes.
Okay.
Guy, isn't it true that the doctor examined the person? Yes. And took a history? Yes. And did this? Yes. And did that? Yes. So then the doctor met the standard of care? No. Why is that? Because of A, B, and C. Because the exam did not do A. The exam did not do B.
So no need to be argumentative over things that are already, that if you can agree to it, agree to it.
Absolutely.
Okay.
If the answer is yes, it's yes. If you need to qualify it, it's yes, but.
Okay.
If you need some additional explanation on redirect from your lawyer, the lawyer is going to know what you need. You know, you've covered this stuff. It's okay to make concessions. It helps your credibility. Right. The other thing is, when it comes to this whole concession thing, you need to be open and honest. You need to be open and honest about your money, about your relationship with the firm, about whether, how much plaintiff's work you do, about how much defense work you do. Let me tell you about a story that I had. I had a case where...
And just a heads up, we got about 7 minutes left to the 40. I think we have more than enough time for everything here, but I just want to leave some questions, please, with the...
Okay. I tried a case a number of years ago against an anesthesiologist who caused spinal cord injury by doing an epidural. He didn't do the fluoro right or whatever. And the defense side hired this expert witness from this ivory tower in Chicago. And he comes in all full of himself. And the MRI showed a clear case of malacia and swelling and damage to the tracts in the cord. And the MRI report and the radiologist testified that there was a spinal cord injury. And I asked him 15 times. He would not agree that there was a spinal cord injury. Finally, I walk up to him and I say, come on, let's say it together. Spinal. Can you say spinal? and then cord, and then injury. And then the jury just cracks up. And the guy lost all credibility because he wouldn't say something that they already heard from other doctors. Okay? All he had to say was, there's a spinal cord injury. The doctor didn't cause it. Or it wasn't a deviation from the standard of care. Or it wasn't malpractice. But yes, there was a spinal cord injury.
And he just refused to do that, and that hurt his credibility.
Yeah, it hurt his credibility, and it showed in the verdict. So it's the same thing regarding money. Don't be ashamed by the money that you charge. Don't be ashamed by the money that you make. Okay? The reason why you make all this money is because you're darn good at what you do.
Right.
A lot of people want to use you. Don't be ashamed, and be open and honest about your relationship with the firm that retains you. It's okay. We're going to handle that together. If we have a relationship, you can say, yeah, I used Mr. DiMartino has used me on a number of cases. I was recently involved in a case where I was an expert on the plaintiff side. The defense lawyer had hired me a number of years ago. You know, he couldn't do anything with the relationship with the firm. And the other thing where a lot of experts get in trouble and cause a lot of discovery to go on about them has to do with this relationship of whether to do plaintiffs or defense work.
Okay.
Listen, we all want an expert that does both because it helps their credibility. But what happens if you deal in the world of torts, where there's insurance companies and third-party payers? If you deal in that world, what will happen is that a lot of times insurance companies will not allow the lawyers to retain experts who are being used by the plaintiff's bar.
Okay.
So it's just the nature of the work. So if you do 95% plaintiff's work and 5% defense work, say it. If you do mostly 100% defense work, say it. And it's the same thing. It could be spun. That's because I'm darn good at what I do. See, what we can't have is you get up on the stand and you waffle and you say, yeah, it's 95-10, and then somebody pins you in a corner and, somebody pins you in a corner and it said, well, when was the last time that you testified regarding X? When was the last time that you testified on behalf of a plaintiff? And it's like 1943.
So then you're not doing 5% plaintiff's work.
Well, maybe you did 95 back then, and you just
Right.
have averaged it over the years. But it goes back to the whole credibility thing.
Right. So and yours was a very interesting take on this, because I'm constantly recommend to the Experts.com members. I'm regularly saying, obviously 50-50 is the best. That's rarely achieved. So 60-40, 70-30. And you said, and this was really surprising to me, Guy, that even if it was 90-10, that didn't necessarily mean you weren't going to use somebody, as long as that 10%, whether it was plaintiff or defense, was in a reasonable time. Like, 9 out of my last 10 cases have been plaintiff, but I did this one defense, and it was 2 years ago.
Right. Exactly. Because, you're going to get odds are you're going to get pigeonholed. If you're somebody that I use, I do more plaintiff's work than defense work. So the people who are going to ask me for referrals are people who do the work that I do. So you're going to get pigeonholed. Or maybe you're on some insurance company's panel. So the insurance company, they dictate to the lawyer, who they're going to retain, whether it's an economist, a voc rehab person, an accident reconstructionist, whatever it be. There are insurance companies that will only allow you to use one engineering company. They're nationwide engineering companies. There are insurance companies that require their lawyers to use one biomechanical expert company in Texas. You know what I mean? So
Right.
That's just the way it is.
Okay.
You have to own it.
Excellent. And it looks like we're here at some final thoughts in just enough time, and then we'll have it looks like we've got several questions that have come in. So give me some final thoughts, Guy, and then we'll take some questions.
Final thoughts is you have to be in this for the long haul.
Okay.
There are going to be, some of the experts that I've dealt with have become very rigid because they've been taken advantage of by some lawyers. Some lawyers have possibly been, under the gun for timing, and at the pre-engagement stage, they already disclosed that person as an expert. You have to understand that there are going to be some bad seeds, and there are going to be some people that, cut you the wrong way, but you can't run your whole life on that. For instance, I don't want to be nickeled and dimed.
Fair enough.
I just don't want to be nickeled and dimed. I'd rather you, charge me the fee and give me what I need, along those lines. But I don't want to get a call when we're in the middle of prepping for something and saying, your retainer's run out. I'm not going to do anything additional until you send me a retainer.
Okay.
We also have to look at the scope of the case. I recently had a canine expert in the case that I paid more money than I did a neurosurgeon in a case. And when you look at the degree of specialty between a neurosurgeon and a canine expert, it just, it just didn't sit well with me. And maybe that was my fault. Maybe I needed to explain my expectations up front. But, I can't spend, $10,000 or $15,000 on an expert on a case that's a $75,000 case.
Okay.
I can't do it.
Right.
It doesn't work. And the last thought is, if you're going to do this expert witness work, you have to be in it for the long haul. There are many experts on both sides of the coin that get burnt out. They get used up. They start to cross lines, and eventually they get caught, sort of like the IME doctors that you were talking about in Las Vegas. They start to become advocates, and they start to, take their position and saying, I'm only going to work for defense people because every plaintiff is lying. Or I'm only going to work for plaintiffs because every insurance company is evil. And that's just not the way it is.
Right.
You know what I mean? You need to be balanced about this work.
Excellent. Thank you so much for that great information today, Guy. It looks like the questions have been rolling in, and a few more are rolling in. Are you ready for some questions?
Let's shoot.
Yeah. So the first one, and I think I can answer this one. Howard asked, spelling the two types of expert classification. Howard, the two that he talked about are Frye, F-R-Y-E, and Daubert, D-A-U-B-E-R-T. So take a look at those. They do differ by jurisdiction. Lloyd asks, do you expect the wish list along with the engagement letter or subsequent to engagement?
It depends. Sometimes we're able to have the wish list up front, but many times it's not until after the initial evaluation. You might tell me, I need this protocol, I need this policy, I need this fact to shore up my opinion. So it might be, longer down in the case. Guy, I need you to go out and get so-and-so.
Mm-hmm. Okay, excellent. Jerry asks, and Jerry's been a long-term member of Experts.com. Thanks for tuning in today, Jerry. He asks, retainers, refundable or not? Should it be a refundable retainer or not non-refundable?
I guess that depends upon how much your retainer is.
Okay.
If you're going to charge me a $1,500 retainer and that's going to handle your initial case review, say I need an affidavit of merit, and it only takes you an hour, and to tell me that I don't have a case, I mean, that's non-refundable.
Okay.
I mean, you keep the $1,500 for your review of, to tell me there's no case.
Okay.
But if you ask for a $5,000 retainer, I think you really need to work your hours off against that.
Okay, fair enough.
So it depends upon where you are in your retainer.
Excellent. And Jerry's got several questions here. Thank you for all these, Jerry. These are good. The trend for depositions, are you seeing a trend that they're happening in the expert's office or in an attorney's office? Have you noticed any trends recently?
That depends. I do a lot of federal court work, and a lot of times the experts are all over the country, and a lot of times they're done at a court reporter's office, because a lot of times we need video conferencing capabilities because there are people who don't want to schlep in from New York and all over. So most of the time I've been seeing them at court reporters' offices.
Okay, fair enough. And we have one more here from Jerry. Thoughts about using or affiliating yourself with an expert witness broker? So this is I have to say that what Experts.com does is not a broker. We don't mark up the billable hours, but his example was TASA. And do you have any thoughts about, do you use that type of an expert witness brokerage firm, and do you affiliate with them as an expert?
I have used expert witness brokers. And I've used them usually when I'm looking for experts that are hard to find. Mm-hmm. Like, for instance, it's very difficult to get a neurosurgeon in a case. It's very difficult to get an OB/GYN that deals with maternal fetal monitoring or some of the specialties. So I will go to an expert witness broker, but the broker that I use for that only takes a fee on the initial getting the expert and then the initial review of the file. Once you all agree that there's a case and they're going to go forward, it's your relationship directly with the expert, and the broker is no longer involved.
Excellent. And I invite you in the future, for those hard to find, to contact me, because I can do that as well.
Yes, absolutely. But I didn't know you back when.
Yeah, I know. That will bring up some money issues, though, in deposition or trial, correct? Oftentimes the brokers, the expert is not aware of how much a broker, the one you're talking about who just did the fee and then it's all between the expert witness and the attorney, that's one way. But oftentimes they'll add a markup to every billable hour and the expert is not aware of what that markup is and how much they're getting paid.
But we still, in discovery, when we are served with expert discovery, we're still going to have to provide those invoices.
Okay.
So the way that the expert handles that in deposition says, this company retained me. I mean, that's what the company billed.
Okay. Good to
know. That's how you handle it. But
sure.
You're going to get the information. The information is going to be out there. They might do a non-party request to the company to get their file and their billing.
Excellent.
If it's that important.
Okay. Scott asks, how do trial graphics influence how you try a case or how an expert is used? It's pretty broad. That's broad, but can you give some ideas there?
Yep. Depends upon the case.
Okay.
For instance, if you're an engineer, Scott, and you use something like PC Crash or some type of animation, I think that it's great going through your numbers, but the only reason why we want you to go through those numbers is so we can support using the animation, because people want the show and tell to see how the crash you believe happened. If it's a medical issue, I think graphics help so much because it helps your teaching style. You're able to get up with the board or the x-ray or the medical literature or the medical artwork and show what happened. This is the instrument. This is us looking, in. So you need show and tell. People just need that as jurors. Otherwise, they're not going to be engaged.
So that's part of just interactive show and tell, kind of, more than anything. Yep. Keeping them engaged. Okay.
I had a treater testify a number of years ago in a cervical case with a disc, and she used a turkey neck, and she passed it around the jury and showed them, and they were handling it and this, that, and the other thing. I thought it was quite effective.
Interesting. Yeah, it's a really interesting thought.
Remember, if you're going to use demonstrative evidence, you have to be able to testify that it's a fair and accurate representation of what the actual thing is. So, she would have had to testify, yes, these are the bones, the vertebrae, similar, this is the disc, there's shock absorbers between the bones, So if you're going to use something demonstratively as an expert, you have to be able to testify that's a fair and accurate representation of whatever it is you're going to use.
Excellent, excellent. We just have 2 questions left here, everybody. We got about 5 minutes, so if you have a question, please jot it in the Q&A section. Sanjay asks, and this is an interesting one because we've had this. I think Mo answered this, or Jennifer may have answered this before. This comes up regularly. What advice do you have for an expert early in their career who's going up against a seasoned expert? This is often a concern. So-and-so's the expert, the expert's expert in this area. How do I do that when I'm plenty knowledgeable in my field, but I'm new?
You have to work harder. You have something that the other person does not have, and we need to capitalize on that. If this person is the expert of experts, maybe they have horrible communication skills. Maybe they're known for all their papers and being, A, B, and C, but their communication skills stink. You know what I mean? It's the same thing with a lot of times I could talk the medical context because that's what I deal with.
Sure.
And I apologize for that. Many times we're better off with community providers, doctors who are practicing in the community, as opposed to people who are university-based. Okay. Because they have more personality. They're able to, explain things better. Because the people at the university, they're, at a tertiary medical center, they're seeing people who are coming from the community, and they're pretty much talking to residents and fellows and things along those lines. So there's always something that we can capitalize on with an expert.
Excellent, excellent. And Scott asks one more question, sort of the antithesis of his last question. How should trial graphics not be used? Maybe you have an example of one that was poorly used, or...
Well, the whole purpose of a trial graphic is to simplify and to be able to teach. If there's too much stuff on the graphic, people get lost in the concept. So, if there's too much information, if there's not enough white space, you can't use one graphic to show everything.
Okay.
So if you're looking at a surgical area, you want to have different graphics that'll take you layer by layer if that's the issue in your case.
Excellent.
Make sense?
That makes great sense. Guy, I want to thank you again. We wrapped it up a few minutes early. You've been fantastic. Can you tell people where they can find your firm or how they can get in touch with you? Although I do ask folks not email Guy and ask him to retain them. But how would you where would our attendees find you?
Well, you can always shoot me an email, but not saying that. You can let me know what you do, or you can contact me on the Facebook or something like that. But my email is gsd at gsdmartino.com. I practice in Central Florida and about 60 miles outside of Chicago also. So.
And you do back and forth, and the website is gsdmartino.com, correct?
Yes, that's one of them. Yes.
One of them. That's right. That's right. And thank you all for being here. Guy, real pleasure. Thank you so much for your willingness to do this. And I'll get the video.
I forgot one tip, which is very important.
Please.
When you are in a videotape deposition, the lawyers are going to be off to the side of you. The lawyers don't matter. When you're having the questions asked, look straight ahead at the video camera, because remember, that deposition is going to be played to a jury or a judge. If you turn off to the side and you look at the lawyer, you're actually turning your face to the side and you're not looking at the jury or the judge who you need to explain the information to. So you might think that you're being rude to the lawyer, but you're not being rude to the lawyer. Look straight ahead at the camera. You can still hear what you're being asked.
That's an excellent point. I'm glad we did discuss that in our preparations, and I forgot that one too. Everybody, thank you so much. We will email you the recording of this, and Guy, maybe we'll come up with something new in the future and have you come back.
My pleasure. Take care.
All right. Thanks.
Bye-bye.
Bye-bye.